There was a non-Korean company based overseas which had adopted a standardized contract for Korean customers. Under the basic principles of so-called private international law, the parties to a contract in South Korea are free to choose the governing law of the contract. The company chose English law to govern the scope of its obligations as a service provider. But when entering into a deal, the company did not explain to Korean customers the English law governing when it can be exempt from the obligation to provide services. One day, certain circumstances occurred in which the company's obligation to provide its services arose pursuant to the South Korean law, but not pursuant to the English law. The company refused to provide its services to Korean customers. A Korean customer sued the company, alleging that the company breached its obligations to customers. South Korea has a law regulating relationships between the parties to a standard form contract. The law is called Regulation of Standardized Contracts Act. According to the law, when entering into a contract, the important terms and conditions in use for standard form contracts should be explained to the other party by the party who prepared the contract. So, the terms and conditions of which both parties do not go through the explanation process may be considered invalid in South Korea. The law makes exceptions when a given subject matter is of the predictable sort that there is no need to bother explaining to the other party. The Korean customer claimed that the matter in question was important and unpredictable because it was provided for in the English law but not in the South Korean law, and that it should have been explained to him when entering into the contract, according to the Regulation of Standardized Contracts Act. The company claimed that English law was the governing law of the contract, and that under English law there is no specific legislation designed to deal with the concerns about standard form contract, which means the parties to the contract do not need to go through any explanation process of certain terms and conditions, even though they are important and unpredictable. Who did the Korean court decide was right?